Today's date is the 12th day of November, year 2008. Time now is approximately 7 minutes after 10 a.m. We're on the record. Will you swear the witness, please?
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Ewers, would you tell us your full name, please, sir?
Larry Wayne Ewers.
Mr. Ewers, you and I have met before, have we not?
Yes, sir.
I think it was at a deposition in another case involving the same parties.
Yes, sir.
And again, at mediation of that case, correct?
Yes, sir.
And throughout the course of that case, you were represented by Mr. Painter, were you not?
Yes, sir.
And Mr. Painter certainly did a competent job for you.
I'm sorry, sir.
He did a competent job for you.
Yes, sir.
You were represented by competent counsel, and he did a competent job for you,
Yes, sir.
both in the development of the case and the settlement of the case.
Yes, sir.
And you had the opportunity of his advice for the settlement of that case.
Yes, sir.
And before you settled that case, you talked to Mr. Painter and relied upon Mr. Painter's advice.
Yes, sir.
And there was a settlement agreement arising out of that case, correct?
Yes, sir.
And Mr. Painter wrote that settlement agreement, did he not?
Objection, Foreman.
Yes, sir.
Right. And did he advise you about the settlement agreement before you signed it?
We discussed it. Yes, sir.
But you have no complaints about Mr. Painter's representation of you in that underlying case?
No, sir.
As a matter of fact, you've engaged him in this case to pursue this case.
Yes, sir.
Right. Have you ever been deposed before, Mr. Ewers?
Yes, sir.
How many occasions?
7 times in one case.
In which case was that?
Ford Motor Company. Larry Ewers versus Ford Motor Company.
And Mr. Ewers, what was that about?
It was a dealership and property that I purchased in Atlanta, Georgia,
How long ago was that?
1983.
And who represented you in that?
Nicholas Chelvis.
Chelvis?
Yes, sir.
Can you spell that for me, please?
Chilbis.
And who represented Ford? Do you remember?
There was 7 different law firms. And no,
At the same time or a different time?
different times.
Do you remember which lawyer took your deposition, or any of the lawyers who took your deposition?
7 different law firms took it. No, sir, I don't remember.
Don't remember any of the lawyers?
No, sir.
And what were the allegations in that case?
The allegation was misrepresentation on the real estate. When we got ready to close, there was a lis pendens case from the previous owner on the property. And the inducement to go from Texas to Atlanta, Georgia had to do with what the property was being purchased for and what the value of the property was.
Okay. Did that case go to trial? Was it resolved?
It went to trial. A summary judgment was issued in favor of Ford Motor Company. We appealed it, and the appeals court for the District of Atlanta overturned the verdict, and we ended up settling it.
And those 7 times represent the only times that you've been deposed?
Yes, sir.
Do you still have copies of those depositions?
No, sir.
Okay. I've asked that question 100 times and never got a yes to it. You were advised correctly. But I always ask it, or try to always ask it. Tell us about any other lawsuits that you've been involved in.
Well, I was involved in a lawsuit in Boston against Mr. Heron. I was involved in the terminology is used differently in the UK than it is over here. I considered it a lawsuit against Christopher Patrick Heron in the UK. And that's all I can remember.
You don't remember?
There was, I'm sorry, sir, there was some, when I had the Dodge dealership here, there was several lawsuits that I was involved in. One was a case of a cab driver sued Chrysler Corporation and the dealership that I owned because the cab driver was murdered. But I was not deposed in that case.
Yeah, I'm not asking about ones that you were deposed in right now. But when I say you, and I mean it with regard to all my questions that I asked today, I mean not only you personally as Larry Ewers, I mean you and any corporation, company, business, partnership in which you were involved, okay? Are all of those, given that deposition, are those the only lawsuits that you've been involved in?
Sir, that I can remember right now, yes, sir.
Where were you born, Mr. Ewers?
Alice, Texas.
Alice, Texas. Yeah. And give me just a broad brush description of what you've done as a career.
As working career?
Yes,
or,
sir.
When I got out of college, I went to work for Ford Motor Company,
Where'd you go to college?
Texas A&I University,
And what was the degree in?
business.
And what'd you do with Ford Motor Company?
I was a sales rep.
What does that mean? I mean, calling on dealerships?
Yes, sir.
How long did you do that?
I went to work for them in November of '69, and I left them in May of 1974.
What did you do after that?
I worked for Charlie Thomas Ford.
What did you do with the Charlie Thomas Ford?
I was F&I manager, finance and insurance manager, a used car sales manager, new car sales manager,
How long did you do that?
until January or February of 1983.
What'd you do after that?
I bought the Ford store in Atlanta, Georgia.
Pardon?
I purchased the Ford store in Atlanta, Georgia.
That's the one that gave rise to the lawsuit we were talking about?
Yes, sir.
Did you actually operate
Yes,
that
sir.
dealership?
Yes, sir.
How long did you operate that dealership?
About 9 months.
Were you the sole owner of that store?
No, sir. I had two partners,
And who were they?
Dempsey Bar and Kenneth Bar.
And why were you only operating it for 9 months?
That's when we found out the legal problem on the real estate.
So then did you close shop down?
Yes, sir.
What did you do then?
I had a part interest in a Ford store in Houston, out in Kingwood, called Ray Sykes Buick.
How long did you do that?
Approximately 12 to 18 months.
All right. What did you do then?
We purchased the Dodge store on the Gulf Freeway.
What's the name of that?
The name of it at the time that we
Yes.
purchased it,
Yes, sir. I'm sorry.
it was Gulf Coast Dodge.
And what year did you purchase Gulf Coast Dodge?
1985.
And who were your partners in that?
Richard Prophet, Prophet.
Sure. I'm not talking loud enough.
No, you talk loud enough, but I'm starting to,
Oh, okay. I'm sorry. And how long did you own that store?
Um, 1995.
And did you sell out to the profits, or how did that end?
Yes, sir.
What did you do then?
For a period of time, I didn't do anything because my wife was going through ovarian cancer.
And how long did you take off for that?
Probably about 3 years.
Right. And what did you do after that?
Started dabbling in the oil and gas business.
I'm sorry, I didn't.
Started dabbling in the oil and gas business.
And how did you start dabbling?
Looking for properties to purchase that had producing wells on them.
And would this be about the period of time of 1998 then?
98, 99, somewhere in that time frame.
And what was your first dip into oil?
I'm not for sure I understand your question.
Well, you were
First,
dabbling, you were looking for properties. What was your first purchase?
we bought a very small piece of property that had some producing wells and immediately flipped them.
And who is we?
I'm sorry, sir. I always I very seldom ever use the word I
Okay.
when I'm describing anything concerning myself.
All right. So it was you personally?
Yes, sir.
When did you form EPD Investments? Or what's the name of it?
EPD management.
Management, I'm sorry.
Probably, sir, probably 2000.
From 1998 or so until 2000, did you flip several properties?
No, sir.
Just one?
Yes, sir.
And you worked basically as a sole proprietorship?
Yes, sir. And I did work for my father-in-law, he was in the oil field supply business.
All right. And what was his name? Or is his name?
Dempsey, D-E-M-P-S-E-Y, Bar.
Bar?
B-A-R-R.
And what was the company that he was affiliated with?
Hub, H-U-B, oil field supply.
What was the purpose of forming EPD Management?
Predominantly, I'd say, for the Christopher Patrick Heron transaction.
I'm sorry. I didn't-
Predominantly, I'd say, for the Christopher Patrick Heron transaction.
And when you say Christopher Patrick Heron transaction, define that for me, please.
The program that I was told that Mr. Heron was providing for us that would spring off the profits from it.
And you filed for bankruptcy sometime in around 1998, is that correct?
Yes, sir.
And that was personally?
Yes, sir.
All right. Was EPD in management in existence at that time?
No, sir.
So EPD management would have had nothing to do with that bankruptcy?
No, sir. That bankruptcy was filed for the enormous legal bills incurred by my wife.
Right. You mean medical bills?
Yes, sir.
Okay. All right. You said legal bills, but you meant medical bills?
I'm sorry.
Yeah.
I'm sorry, medical bills.
Yeah, it's fine. How did you first find out about the Heron transaction?
I was called in either April or May of 2000 by it was by Mr. Buckley, if I could drop by his office.
Is that Bruce Buckley?
Yes, sir.
And did you have a relationship with Mr. Buckley before then?
We had been dealing with Mr. Buckley on programs of this sort since late '99 when I first met Mr. Smith.
When you say programs of this sort, what do you mean by programs of this sort?
I will refer to them as a high yield investment program.
And what is the concept of the high yield investment program, as you understand it?
As I understood it, was that a client would put up X number of dollars, and for return of that, he would receive an X number of dollars profit.
And you said that's what you understood it to be then. Do you have a different understanding now?
I'm not sure, sir, that I do understand exactly what it is.
Right. What has caused you to change your understanding of what it was, and to the point now you're not sure you understand?
I personally have never been able to confirm if they exist or do not exist.
Whoops. I'm sorry. I couldn't do that if I tried. And you said that there were some other transactions that you would describe as high yield investment programs before Mr. Herring that you were involved in?
Yes, sir.
Tell me what the first one was.
We're talking a long time, sir.
I understand.
We're talking 1990, late 99 and early 2000. There was a group.
You don't have to get them in order. I just want to know your best recollection of which ones.
There was a group with Dr. Kralik. There was a group from a gentleman that lived in Utah. Dr. Kralik also lived in Utah, but another gentleman that lived in Utah. There was a $1 million program in which I brought two gentlemen in, one from Atlanta, Georgia, and one from Memphis, Tennessee. Those are the three that I believe that we had worked on before the Herring transaction.
When you describe it as a high yield investment program and you say it's a Herring transaction, how would you describe Herring's role in that high yield investment program? Broker? Or do you have another label for it? I'm just trying to get a working label with it.
I would not have described Mr. Herring as a broker in it. I was told that Mr. Herring was a facilitator.
And what did you understand that he was supposed to do as a facilitator?
Bring the two parties together.
And the two parties being which two parties?
The individual that supplied the money or the line of credit, and the individual or entity that actually conducted the trades.
And what did you understand they were trading?
I was never fully consonant of what they were actually trading. I'd heard bank notes. I had heard pretty much that's it.
Did you have any professionals review this concept back then?
No, sir.
Did you have any, and I'm not talking about lawyers, okay, have you had any professionals review that concept since then?
Will you please define the use of the word professional?
Somebody with business training and background other than yourself, who would look at the purported arrangement and give some kind of opinion on it.
I asked a law firm in the UK to conduct some due diligence on it.
Was anything discovered in that due diligence?
Nothing definitive.
What was discovered that would be not definitive?
They could never find through their investigation that they actually took place.
Was it your understanding that the money that would be put up by the investor could not be touched by the solicitor? I mean, the facilitator?
Yes, sir.
And the yields, we were talking about the investment yields that you were considering back then, at what level were they?
When you say what level, sir?
10% a year, 10% a month, 10% a day? What?
I don't remember.
All right. Do you have any concept as to how high the yield was?
Well, I believe the Heron contract was for approximately 5 or 6 months, and it was for $1.98 billion. And what Mr. Cho had placed in a bank account was $220 million. So it was round figures 10 times.
Did the enormity of that yield concern you?
It gave one a moment to pause as how it could take place.
Did you ever figure out how it could take place?
I never figured out for myself. I can tell you the way it was described that these trades were conducted 2 and 3 times a day, 5 days a week.
And did you come to believe that actually took place?
Objection form.
Yes, sir. I've spent a lot of money, and so I had to believe it at some point in time.
Do you still believe it?
I have my doubts.
Why do you have your doubts?
Because we have not been able to find any of the money.
Mr. Green, I'm going to have to ask you to instruct your client to restrain himself. He's kind of making some noises and making faces at the witness, and I don't want to repeat of what happened in Ozona.
Well, I don't know what you mean by that comment, but I'm sure he will comport himself with professionalism. Were the other deals before the Heron deals, did they involve Heron at all?
No, sir. Well, I say no, sir. I never heard the name of Heron until either late April or early May of 2000. I did not know who the facilitators were in these others deals other than Dr. Kralik.
When you say you spent a lot of money, did you ever actually invest money into the program, direct investment?
No, sir.
You're talking about money that you spent to try to find money after the fact.
Yes, sir.
And how much have you invested?
I instruct the witness not to answer that question to the extent it invades attorney-client or work product privileges.
Well, there was a claim made at one time of $300,000 investment. Is it more than that or less than that? And he may want to instruct you on it. when I ask you a question, I don't want to get you to violate any instruction he gives you. But I may ask a question over, but be cognizant of the fact that that doesn't mean you don't necessarily have to follow your lawyer's instruction on, okay?
Yes, sir.
Is it more or less than 300,000?
Same instruction.
Another thing too, and I don't want to have to repeat this, and I'm sure we can have an agreement on it. I'm assuming that you're going to follow your lawyer's instructions today, and that when he instructs you not to answer something, you're not going to answer it. Is that a fair assumption?
Yes, sir.
I don't need to ask that question every time because you're going to follow his instructions every time.
Yes, sir.
All right, can we have that agreement, Robert?
Yes,
Okay.
Mr. Green. And Mr. Green, just to be clear, my instruction is just not to answer to the extent that it would invade attorney-client or work product. To the extent that it doesn't, you can answer the question.
Can I ask some clarification from you?
Absolutely.
It seems to me, and I'm not arguing with you, it seems to me that the amount paid for an attorney's bill does not invade the attorney-client privilege in any way. Does your instruction to him that he cannot answer the amount he has paid in attorney's fees? I'm not talking about your fees. I'm talking about attorney's fees in search of the money.
That's fine.
Okay.
That's fine.
Can you tell us how much you paid in attorney's fees in search of the money?
No, sir, I can't tell you right now exactly what I paid.
Would it be more than 300,000 or less than 300,000?
Am I to answer this question since you've objected?
You can. You can answer that. You can answer the question if you have personal knowledge and recollection of the amount.
It is more than 300,000.
Is it more than 500,000 or less than 500,000?
It is more than 500,000.
Is it more than $1 million or less than $1 million?
It would be in that range.
Range of $1 million?
Yes, sir.
Where'd that money come from?
Through some from myself and other monies that I borrowed.
And who did you borrow money from?
I borrowed money from Dempsey Bar.
Your father-in-law?
Mm-hmm.
Who else?
I got money from Don Weiss.
Who else?
That's all.
And is there any agreement from those two individuals documenting that loan?
No, sir.
Have they taken any percentage interest in anything you find?
Don Weiss has
And what percentage?
33.
How much did Mr. Weiss lend you?
Sir, I don't have that number exactly.
I mean, is it as much as a third of the amount you've spent?
It would be more than that.
Half?
And probably would be more than half.
60, 70% in that range?
Yes, sir.
And what about Mr. Barr?
Probably 15, probably somewhere around the neighborhood of 15%.
Which would leave about 15% of your own money?
Yes, sir.
Any other contributors?
No, sir.
What have you spent the money for? We mentioned law firms. There's some law firms that you paid.
I'm going to instruct the witness not to answer any more questions on this line because I believe these questions are falling outside the scope of the rules.
How is it outside the scope of the rules?
Well, this is not something that's related to the pleadings of the lawsuit, so it's not relevant. It's not reasonably calculated to lead the discovery of admissible evidence.
I respectfully disagree. I'm not going to argue with you, but just to put my point on the record. It is certainly calculated to lead to relevant and admissible evidence. This whole lawsuit is about where the money is, or if there is any money. We are certainly entitled to discover and go into what efforts have been made and who has made those efforts to discover that money. And that's what I'm getting at. Are you still instructing him not to answer?
I am still instructing. And Mr. Green, just to, on one other basis, since you asked for an explanation, any efforts to locate money that predate the settlement agreement are integrated into the settlement agreement, so those would also be irrelevant.
Well, my position on that is the whole lawsuit is integrated into the settlement agreement. This whole lawsuit is integrated into the settlement agreement. And I don't want to go through all of them, but I have a lot of questions on what was done to locate money prior to the settlement agreement, because I think that goes to our pleadings with regard to breach of fiduciary duty. And that was owed, and those are what our pleadings are. And I think it's certainly relevant and calculated to lead to that. So I don't really know how to handle that.
Well, can we go off the record for a second?
We're off the record at 10:38.
Actually, didn't drink too much coffee this morning.
Time now is 10:40. We're back on the record.
I would like to make the last point that I made off the record, and hopefully we can come to at least how to resolve it and get it resolved maybe later and come back and finish. It is our position that you all have sued based upon a claim that representations were made with regard to where money was. Part of that cause of action, of course, depends upon a proof of reliance. That makes the issue of where money is relevant to this lawsuit, and what the plaintiff knows about where any money is relevant to this lawsuit. There have been representations made, and I'm going to go through those too, about certain sums and where they might have been made. I think that is clearly relevant to this lawsuit. But I understand your position is you're going to tell him not to answer any questions with regard to any efforts that were made to locate prior to the settlement of this case.
That's partially correct. If you have any questions specifically about Mr. Ewers making representations that sums were in fact located by him or any money was recovered by him, I would think those would be relevant, and I would not instruct the witness to answer or not to answer on those. But for any general research or general information that he had obtained through his research prior to the settlement agreement, the instruction would stand. Does that make sense?
Yeah, it makes sense, and we'll know a little bit more when we go forward. But for the present purposes, I'm certainly going to respect your instruction with assumption that he wouldn't answer it if I asked him. But I'm certainly reserving the right to come back and finish the deposition once we get a ruling on that issue.
Agreed.
Okay. Have you located any money in any way related to Mr. Herring?
No, sir.
Not at any time?
No, sir.
You don't know the location of, in all of your efforts to find money prior to the settlement of this case, you did not find any money in anywhere in the world that might have any way been related to Mr. Herring?
No, sir.
You or anybody else that you know of?
No, sir.
So the $1 million or so that you spent was entirely wasted?
Yes, sir.
Okay. I had a conversation with Mr. Spiro in which he said that there is money related to this, or everybody thinks there's money related to this throughout the world. Do you know what he meant by that?
No, sir. I was not privileged to your conversation.
Well, I asked you to assume that he said that. You would have no reason, you would not know anything he could possibly base that upon.
No, sir.
Because you don't have a clue as to where there might be any money in any way related to Mr. Heron.
Sir, as of this day, we have found no money that we can directly relate to Mr. Heron.
Okay, well, let's talk about the money that you found that you can indirectly relate to.
There is no money indirectly.
All right, so you have found no money that you can directly or indirectly relate to Mr. Heron.
Yes, sir.
Are you still looking?
No, sir.
Then why are we here in this lawsuit? Why are you trying to set aside a deal if there's no money?
I'll instruct you not to answer that. That's on the basis of attorney-client privilege.
I'm not asking what your attorney said to you. You brought a lawsuit to set aside a settlement agreement, have you not? You understand that?
Yes, sir.
Why have you done that if there's no money? Why set aside a settlement agreement, giving up money, if you hadn't found any money? You already spent $1 million trying to find money, and you're not looking for any money. Why set aside a settlement agreement?
For the same reason that I agreed to settle the lawsuit in Ozona, Texas, based upon statements that were made at the mediation by Mr. Smith and by yourself, Mr. Green, that Mr. Smith had his sources had located $1 billion+ and that those funds would be deposited into the registry of the court in Boston within 30 days after the judgment was rendered.
All right. And was that statement made, you said that was made by me and by Mr. Smith at the mediation?
Yes, sir. And also, Alan Levin also came in and told me that.
Okay. And that's the first time you'd heard anybody say they knew where the $1 billion was?
That's the first time that I directly had heard it, yes, sir.
When did you indirectly heard it?
I heard conversations. I had a conversation with Mark Matthews prior to going out, and he alluded to it.
Prior to going out to the mediation?
Yes, sir.
All right. What did he say?
Is that he had been told that Mr. Smith was making claims that his sources or contacts had located over $1 billion.
Okay. And who had told Mr. Matthews that?
I'm not sure, sir.
All right. But the first time you had ever heard anything from Mr. Smith about that was at the mediation?
Yes, sir.
Did you hear it from Mr. Smith after the mediation?
I've had no conversations with Mr. Smith. There's been correspondence which the claim has been made. One of the correspondence you made. Mm-hmm. You sent a correspondence on September the 18th in which you alluded that there was enough to satisfy the judgment in Boston.
And that was September 18 after the...
2006.
All right, after the agreement, the settlement agreement had been entered into.
Yes, sir.
And there was a settlement agreement reached, was there not, at that mediation?
Yes, sir.
And that's the settlement agreement you're trying to set aside?
Yes, sir.
And the first time you heard a direct representation with regard to Mr. Smith's claim was at that mediation?
The first time I heard it directly that I could say that, yes, I heard it direct and I knew that that statement was being made.
Right. Any other statement made before that wasn't made to you?
No, sir.
Or to your attorney, as far as you know?
My attorney would have to answer that question, sir.
You know, you have no reason to believe that any statement like that was made to you before, or to you or your attorney or anybody representing you prior to that mediation?
Yes, sir. I believe that statements were made to Mr. Painter that alluded to the over $1 billion being located.
Okay. The only representation you have personal knowledge of about $1 billion being located by Mr. Smith, a representation either from me or Mr. Smith, came for the first time to you directly at the mediation?
In the opening session of the mediation, yes, sir.
Well, we didn't have an opening session of the mediation.
Yes, sir. We had a very short one.
Okay. And it's your sworn testimony that I, in the opening statement at the mediation, said that Mr. Smith had $1 billion?
No, sir. It is my sworn statement that you confirmed what Mr. Smith had said.
How did I confirm it?
Is that Mr. Smith's sources had informed him that they had located over $1 billion.
How did I confirm that?
You didn't allude to how you confirmed it, and I don't believe no one challenged you on it.
Well, why do you say I confirmed it?
Mr. Smith had made the statement, and you confirmed it
How did I confirm it?
vocally.
Vocally, what words did I use to confirm it?
Sir, I'm not going to quote you because we're talking a period of time about exactly the word you use, but I will generalize that you've made a statement that, yes, that you had been told that Mr. Smith's sources had located over $1 billion.
Any other statement?
No, sir.
That's the sole statement,
As far as I can remember, yes, sir. And then Mr. Levin came in after the party split up when he was trying to convince us to take a lesser share, is that Mr. Smith had made those statements to him.
The statement that his sources had located $6 billion, over $1 billion.
Yes, sir.
Any other statements?
Not that I can remember, no, sir.
Did you believe that?
I believed it when I looked at you and your reputation and that you were confirming it. Yes, sir, I believed it. Because I felt like that you had probably done the due diligence that was necessary to confirm what your client was stating.
And your claim is that I somehow gave some expression confirming that statement.
Objection form.
Yes, sir.
But you don't remember what the statement was.
As closely as I answered it a while ago, my answer would still be the same today.
Well, with all due respect, you didn't answer it a while ago. I asked you what
I
words.
gave you a generalized,
You said orally.
orally of what you stated in there. It was not in a written form. It was made in an orally fashion.
Prior to the mediation and after the filing of the lawsuit, you and I had no conversations, correct? Other than at the mediation itself.
Correct.
You mean this lawsuit?
Not this lawsuit, I'm talking about the other lawsuit. A lawsuit that was settled.
No, sir.
And you had no conversations with Mr. Smith.
No, sir. Well, let me back up. You and I had a short conversation at the deposition of Mr. Liner in Ozona, Texas.
Right. And at the deposition
Of Mr. Liner.
had nothing to do with where money was
No, sir.
or anything like that.
No, sir. You were upset because Mr. Liner and I were talking,
Right. I remember that.
and you asked me to cease my conversation with Mr. Liner.
Okay. Other than that, any conversations?
No, sir.
Any conversations with Mr. Smith?
No, sir. But there has been numerous conversations from individuals. There has been telephone calls from anonymous sources confirming this. There's been statements made by Tom O'Dell that alluded to this.
When you say anonymous conversations, people just calling you on the phone?
Calling business associates, sending letters An example is a letter of May 4th, 2007 that you wrote to Mr. Painter that was sent to individuals. There's been telephone calls to individuals that shows up as a unknown caller.
And do those telephone calls, is your testimony, those telephone calls relate to money being found? Or,
Yes, sir.
and do you have any recordings?
No, sir.
Were those telephone calls being made to you?
No, sir. As I stated previously, those telephone calls have been made to associates.
Well, tell me who.
One is Ben Lassiter, and I was asked not to divulge the names of the others, and I will honor that request. One was made to my mother.
Well, we need to know who the other two are, but we can take that up however you want to take it up.
I'll talk to him on the break.
Okay, that's fine. That's fine. And what is your understanding as to what was made in those conversations?
My understanding was about that I was refusing to cooperate, and that money had been found, located, and that I was getting ready to go to jail.
And do you know who was making those calls?
No, sir.
Let me go back to my other question. If you have spent over $1 million and haven't found a penny either indirectly or directly related to Mr. Herring, and since the settlement, you have not done anything whatsoever to try to find any money, why try to set the settlement aside? I mean, the settlement divides money of Mr. Herring, does it not?
Objection form.
Yes, sir.
I guess I don't see the point in bringing a lawsuit to set aside an agreement to divide something when there's nothing to divide.
There is still a belief that with statements that was made by Mr. Smith and by yourself, that Mr. Smith's sources perhaps has found money that we were unable to find. As the letter of May 4th, 2007 indicated, David Walls and his credentials and others that was mentioned in the May 4th letter.
And you believe that?
I don't know whether to believe it or not believe it, but I believe that if statements were made by yourself, that you had reasons to believe it.
But you don't know whether or not you believe it.
I can't get into what information you have that I don't have, so it's hard for me to say where I believe it or disbelieve it.
Excuse me, I'm not asking, are you through? I didn't mean to cut you off, I'm sorry.
That's all right.
I'm not asking you to assume what anybody else knows. I'm just talking about what you know personally. Do you believe it or do you not believe it?
I'm not sure.
What is your present relationship, if any, with Buckley Matthews?
I don't have a relationship with Buckley Matthews.
Has Buckley Matthews ever, or any of the lawyers affiliated with him, ever represented you in anything?
Bruce Buckley represented me in 98 or 99 and something I was looking at.
All right. Hadn't represented you since?
No, sir.
And whatever he was representing you in has nothing to do with what we're talking about here
No,
today?
sir.
So there's no attorney-client relationship between you and Mr. Buckley?
No, sir.
Has not been at all with regard to what we're talking about here today?
No, sir.
Same would be true with regard to Mr. Matthews.
Yes, sir.
Were there any other people involved in EPD?
No, sir.
Who is Lawrence Marchman?
A friend of mine
How long you know Mr. Marchman?
since 1969.
And have you ever had any business dealings with Mr. Marchman?
Yes, sir.
What have those been?
We was partners in a car dealership in Conroe, Texas.
Anything else?
We were partners, or we have worked together in oil and gas deals, but we never closed one that we worked together on.
Are you in any way affiliated with Phoenix Mining?
I'm affiliated with Phoenix Mining and Mineral.
All right. And what is your affiliation?
I'm the president of it.
Who else is involved in that company?
I'm going to have to give the same instruction not to answer this question because under Rule 199.5F, it's not in compliance with the scope of the rules.
How long has Phoenix Mining been in existence?
Same instruction.
Okay. You're president of Phoenix Mining, you gave us that, correct?
Yes, sir.
Phoenix Mining has been involved in lawsuits, has it not?
No, sir.
Phoenix Mining's never been involved in a lawsuit.
No, sir.
Okay.
No, I'm sorry, sir. Yes, Phoenix Mining and Minerals is involved in a lawsuit
And what lawsuit is that?
against Treasury Oil.
And what is that lawsuit about?
There's other main parties in the lawsuit, sir.
And what are they?
Treasury Oil, Treasury Capital, Treasury Leasing, Irvin Birnbaum, Ron Oregon, Gart Collier.
What's that lawsuit about?
Failure to perform on a contract.
Failure to perform what contract?
Contract between Phoenix Mining and Minerals and Treasury Leasing. I'm sorry, Treasury Oil.
A contract to drill?
No, sir. Contract to purchase producing properties.
And is Phoenix Mining the plaintiff in that case?
Yes, sir.
Is that still pending?
No, sir.
How was that resolved?
We got judgment on the defendants.
Was that a default judgment?
Yes, sir.
Do you know Bobby Howell?
Yes, sir. Mr. Howell is part of, listed as a member of Phoenix Mining and Minerals.
How do you know Mr. Howell? Through Phoenix Mining and Minerals?
I was introduced to Mr. Howell by B.J. B. George.
B.J. Borgie?
Mm-hmm. Oh, pardon me on the pronunciation.
Did I mispronounce it?
No, sir.
I did pronounce it right?
Yes, sir.
Okay. How do you know B.J. Borgie?
I received a telephone call from him back in 2002, 2003. I received numerous telephone calls from him in 2002, 2003.
Just out of the blue?
Yes, sir. Out of the blue.
What were the calls about?
That he could help in the location of monies belonging to Heron.
Did you engage him?
I'm sorry.
Did you engage him?
Yes, sir.
And what did he do?
Nothing.
Did you give him any money?
Paid him a monthly salary. Yes, sir.
Who's Tom Moss?
He is an employee of Phoenix Mining and Minerals.
What is his job?
to help locate oil and gas properties.
Is Phoenix Mining and Minerals still in existence?
Yes, sir.
Who's Noel Thomas?
Noel Thomas was introduced to me by Mr. Georgie as a station chief for the CIA in Houston, Texas.
Did you engage him?
No, sir.
What conversations did you have with him? Any?
I met with him probably 2 or 3 occasions. And the promise is that BJ had told me that Mr. Thomas could perform. Mr. Thomas made it very clear that he could not perform those duties,
And what was represented to you that he could perform?
that he could help in the location of funds belonging to Mr. Herron.
And he told you he couldn't help you on that?
Yes, sir.
Why did it take 2 or 3 meetings for him to tell you he couldn't help you?
Sir, you'd have to ask him that.
Well, did he not tell you in the first meeting?
No, sir.
Did he indicate to you in the first meeting that maybe he could help you?
He didn't indicate anything, sir.
Did you give him any money?
No, sir. I believe I've answered that question.
Walter Peoples?
That name not familiar to me.
Lauren Noel? Nowell?
That name's not familiar to me.
BJ Borgie, we've talked about. Do you have any relationship with him today?
No, sir.
Mr. Samuels?
Would you give me his full name, sir?
I don't have it right here. I think he's an attorney that may have represented you at one time. We can pull it up in a little bit.
You would need to pull it up.
And you mentioned a while ago, I think, do you know a David Wiles?
Yes, sir.
How do you know David Wiles?
He was introduced to me by Mr. Smith.
And who is David Wiles?
That's a good question, sir. I can't give you an answer to that.
Okay, but you've actually met him?
I met him the first time in January of 2001 in London, England.
Have you met him more than once?
No, sir.
What did he represent to you, who he was? How did he represent to you who he was?
I'm not for sure he represented to me anything about who he was or thing. I think he assumed that I had been informed as to what he was.
We talked earlier about Don Weiss.
Weiss.
Weiss, okay. What is your relationship with him?
Mr. Weiss and I has done some deals, partnerships, deals together.
You still work with him?
Yes, sir.
Is he part of Phoenix Mining?
No, sir.
Is he part of EPD?
No, sir.
Is he part of any other organization that you're a part of?
Today, no, sir.
Was he at one time?
We looked at deals together, but we didn't close them.
Have we discussed all of the organizations that you've been a part of? And I don't mean clubs. I'm talking about business entities that you've been a part of since '95.
I have a company called Energy Group of South Texas, LLC.
Energy Group of South Texas, and there was another one?
LLC.
Okay. Any other?
No, sir.
Have you ever had any deal that went through with Mr. Wise?
No, sir.
So your entire involvement with Mr. Wise was him loaning you 60 to 70% of the near $1 million to try to find Heron some money, and then some other deals that never went through. That's the total involvement with Mr. Wise.
Yes, sir.
Okay. And I think I asked you this, but I don't. You may have told me, and I apologize. With regard to these loans, is there any documentation of that agreement?
As I previously stated, no, sir.
Okay. Just handshake deal?
Yes, sir.
How do you keep up with the amount of money?
It's pretty easy, sir. It's pretty easy. Mr. Weiss keeps a record of it, and I keep a record of it.
So the only involvement you would have with Mr. Weiss would be directly involved with the location of Heron money.
Correct.
Have you kept him informed of your efforts?
On a limited basis.
What do you mean on a limited basis?
On a limited basis. He's not been informed of everything we've done.
You keep him generally informed about it?
On a limited basis.
Well, what limits do you put on the basis of information?
It's a very limited basis as far as what law firm we're using.
So the only thing you've told him is what law firm you're using?
Yes, sir.
And he hadn't asked any questions?
No, sir.
Even though he's got $500,000 in?
Yes, sir.
Have you at least told him, hey, we hadn't found anything?
Yes, sir.
Okay, other than what law firm you're using and the fact you hadn't told him that you hadn't found anything, is there anything else you've communicated to him?
No, sir.
What about Mr. Barr?
No, sir.
Have you told him what law firms you use?
No, sir. I've given no information to Mr. Barr.
Sorry. Have you had any business dealings with Mr. Hurd?
Yes, sir.
What kind?
We borrowed some money for the deal in Laredo, Texas. That is the cause of the lawsuit filed against Treasury and the other named defendants.
You borrowed money from Mr. Hurd to pursue the lawsuit?
No, sir.
Okay, well, explain it to
I
me.
believe I just stated that I borrowed money from Mr. Hurd as part of the earnest money that was put down.
Was he a party to the lawsuit
No, sir.
in South Texas?
No, sir.
How much did you borrow from him?
I'm going to instruct the witness not to answer that again. We're outside the scope of the rules.
How many powers of attorney did you get from Mr. Liner?
3.
Okay. Why did you get 3?
Wording were changed, which each time the power of attorney appeared to me, it appeared to be stronger.
Mr. Green, whenever it's convenient for you, could we take a short break?
now.
Time's 13 after 11, we're off the record.